Thank you. Please be seated. Good morning. We're here for oral argument in case number CR170547, the matter of State of Arizona versus Don Jacob HAVATONE. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your clients at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed the case in conference. Counsel, you may begin.
Thank you, Your Honor. Good morning, Your Honor. Pleases the court. My name is Virginia Cruz from the law offices of Sean Hamp. We continue to represent Don HAVATONE in his appeal. This is a case, obviously, with a long procedural history now. This is a case that, because it occurred, the events occurred, the accident, and then the transport of Mr. HAVATONE in rural northwest Arizona. This is a case that is one that makes sense in that context. When the Arizona Supreme Court remanded this case and found that its concerns with the exclusionary rule and deterrence would still be in place because of the Arizona Department of Public Safety's practice and across-the-board practice of not even trying to seek a search warrant before obtaining blood samples from individuals, that kind of, again, is put in context with how rural northwest Arizona is. Maybe not much different than Yuma County, but certainly in Arizona it is a common occurrence, if not all of the time occurrence, where when folks are injured, whether it's in a single car accident or multi-car accident, the closest trauma centers are accessible by Care Flight in Las Vegas. So this is, at the time of this accident, it was the common practice of DPS to just request the blood and make no attempt at obtaining a search warrant beforehand. There's no reason to believe, even in 2012, that the DPS officers, if they had a different procedure, could not have reached out to a local judge or magistrate for a telephonic or even in-person search warrant.
But Mr. HAVATONE was in Nevada, so what reaching out to an Arizona magistrate would, unless you can tell me otherwise, Ms. Cruz, that reaching out to an Arizona magistrate wouldn't have any effect once Mr. HAVATONE was in Nevada. Right.
He was receiving, though, medical treatment on scene. So, again, I don't think time frames were super clear about how long he was on scene before the transport, but no attempt was made. And, again, that was based on the DPS policy at the time to never even entertain the idea of trying to obtain a warrant in state, or, and it seems to be Nevada's procedure at the time as well, to not seek a search warrant before obtaining blood.
And in Nevada, that was constitutional at the time, correct?
I believe it was, yes. But the problem that we have in this case is that the Nevada DPS officer, Reinmuth, did not seem to have the knowledge or the concept of what would have made it constitutional, or if it was. He was going on his department, the Nevada DPS's policy of never requesting a warrant as well. So,
but again, that practice was constitutional in Nevada at the time.
Well, I think it was constitutional probably a lot of places before McNeely. But again, whether that was the constitutional practice, I think the Arizona Supreme Court's issue was that the deterrent effect would be completely missed if police are allowed to follow practices that...
Well, if we applied Arizona law, how would that deter a Nevada law enforcement officer?
I'm sorry?
If we applied, in your brief, you want us to apply Arizona law.
Correct.
If we did that, and the main purpose of the exclusionary rule is to deter police misconduct, how would that deter Officer, is it Reinmuth?
Reinmuth, yes, Your Honor.
How would that deter his action since he's not subject to Arizona law?
Right. But it would have been no different in Nevada for the policies in Nevada were the same, apparently, as what they were in Arizona, where there was no attempt to obtain search warrants or even think about getting search warrants. And this is different than the Byers case out of Nevada that came after, where the court finally rendered a portion of the implied consent with regards to blood draw unconstitutional because it didn't allow a conscious, non-consenting person the ability to withdraw the implied consent. And with an unconscious person, it would seem to be even a higher bar that the officers would need to meet. And again, the conduct of Officer Reinmuth is no different than the conduct of Officer Perea in Arizona, which the Supreme Court here in Arizona took issue with because, again, it was departmental practice and it wasn't something that was, had basis or reliance where that particular procedure of the unconstitutional warrantless draw had basis.
So you made an argument that I'm not quite sure I understand, which is you don't know how long your client was on the side of the road before being transported. Is that correct?
Correct.
And it seemed to me that you were suggesting that the officer in Arizona should have gotten a warrant and taken your client's blood prior to transport. Is that what you're suggesting?
Well, it would seem that he was on scene while the defendant was still on scene, and there was at least enough time that he was questioning the people on scene as well as the defendant for some period of time before he was transported. So, yes.
So are you asking us to adopt a policy that police officers can delay medical treatment in order to obtain a warrant?
No, I'm not saying that. I'm just saying the record doesn't have any information of how long he was still in Arizona. So when Judge Bean asked about not being able to obtain a warrant in Arizona, I don't know that that's accurate. And I'm not suggesting at all, because it was life-saving treatment that Mr. HAVATONE had to receive in Nevada through the Care Flight transport. I was just suggesting that there was arguably some period of time that he was still in Arizona, and it could have been a lengthy amount of time. I don't know how long it took Care Flight to respond, but they were in a portion of Mojave County, even though it's outside of Kingman. It's between Peach Springs and Kingman, maybe closer to the Wallapai Tribe reservation. So that's all I was suggesting, was that there was no effort made to obtain a warrant, and it's likely that without delaying any medical treatment, one could have been obtained. This isn't a case where there's a medical blood draw exception. The state has conceded by now that there weren't exigent circumstances otherwise that were known to the officers. It's certainly not a case of consent because Mr. HAVATONE was unconscious, and even when he was still in Arizona, he was in and out of consciousness. So
let's go back to the scene of the accident. You have a police officer, and we don't expect police officers to be constitutional law experts. Agreed?
I would agree that they're not, yes.
Okay. And they are charged with following their department's policy, correct?
Correct.
So let's just think hypothetically. We're on the side of the road. We've got the officer on scene. We've got a man that is in and out of consciousness waiting for life-saving medical care. So the officer gets on the phone and requests a warrant. The warrant isn't produced before he is transported. Does that change your analysis at all?
Not really, because again, the problem that the Supreme Court found in this case was that there was no specific case-specific circumstance that were looked at, and there was a blanket policy by DPS at that time to never seek a warrant. I'm just saying that in addition to them having a policy of never trying to seek the warrant, if they had a different policy or if this officer had tried, it's possible that a warrant could have been issued.
Okay. And let's assume he didn't get the warrant. Let's assume he tried and did not get the warrant. So he calls Nevada and says, Nevada DPS, I'd like you to obtain blood. I need you to obtain a warrant first, and I will have to fax you my affidavit of probable cause for that warrant probable cause to attach to the warrant so that the magistrate can make an independent determination. Is that the way you see this happening?
If under that hypothetical they had tried here in Arizona and then they had given more direction to Nevada, yes. But again, Nevada at the time, through Officer Ranmuth's testimony at the motion to suppress, was that he never sought a warrant. So I don't know what they would have done with that.
Okay. Let's say the officer here didn't seek a warrant, but instructed the officer in Nevada to seek the warrant, and the officer in Nevada said, our policy is not to obtain a warrant. Mm-hmm. So he went and got the blood. Does that change your analysis at all?
It does not, again, because I think it's akin to what they were doing in Arizona, where not just the hypothetical of Arizona not seeking a warrant, but that was their practice at the time, never trying to seek a warrant. And again, because the Supreme Court analyzed, even though McNeely came later, there was still the Sherber Law for almost as many decades as Mr. Havatone was alive at the time of this incident, that it's still well known that there needs to be case-specific reasons to seek the intrusiveness of taking blood from someone. So again, I think Nevada DPS had a very similar, if not the same policy as Arizona DPS, so that wouldn't change our position.
So when you say that the policy was never to seek a warrant, do you mean never to seek a warrant under these very specific circumstances where a person was in need of life-saving medical intervention and had to be airlifted?
Even more broadly, I believe in Nevada, in Arizona as well, to not seek the I'm not sure if you
Let's
clarify
stay with
between
Arizona for now.
Okay. In Arizona, that their blanket policy, if someone was transported out of state, which again in Mojave County is a regular occurrence, their blanket policy was to never seek a warrant for blood draw. So.
Okay, and so how would that process go forward if they did seek a warrant for someone who's not here within the boundaries of the state?
So I've seen that done since, where they ask a local magistrate for the blood draw, and then out-of-state authorities give deference to that and have taken blood. So I don't know. I don't believe that's been challenged, but that is a process now. So. And if the court does not have any other questions at this time, I'll reserve the rest of the time for after. Thank you.
Good morning, Your Honors. My name is Terry Christ, and I'm representing the state of Arizona. May it please the court. When applying the Davis good faith exception, the relevant binding precedent comes from the jurisdiction where the search occurred, not the jurisdiction where the evidence is to be admitted. And the reason for this is quite simple. The good faith exception is all about deterrence. The touchstone of both the exclusionary rule and the Davis good faith exception is whether the suppression would actually deter police misconduct. And applying Nevada or Arizona law to a search that occurred in Nevada would have no deterrent effect on either officers in Arizona or officers in Nevada. And I think a hypothetical might best illustrate this point. If you imagine that a defendant robs convenience stores in states A, B, C, and D, and then goes to hide in state E, if you're an officer in state E, whose binding precedent should you follow? Should you follow the binding precedent of your own jurisdiction, state E, or are you somehow required to know and apply the binding precedent from the first four states? What if the binding precedent is conflicting in those states? What are you supposed to do? And I think this only illustrates how messy this rule could be if we required officers to follow other states' jurisdictional law when performing a search. I also think that really when we look at this question, it ultimately needs to come down to deterrence. So what we have to ask ourselves is who could be deterred by applying Arizona law? There are two actors here we could consider. The first would be the Arizona officer, and the second would be the Nevada officer. Well, clearly for the Nevada officer, there wouldn't be deterrence if we applied Arizona law, because the Nevada officer will apply Nevada law regardless of what happens to the evidence somewhere else. So regardless of whether Arizona suppresses the evidence here or not, the Nevada officer is going to do what Nevada law and Nevada's binding precedent authorizes.
But
So
if we stop there real quick, you're saying it has no deterrent effect because they're going to apply Nevada law and Arizona's going to apply it. Wouldn't it have the deterrent effect on the Arizona officer who knows the transport is going to occur across state lines to get that warrant?
Well, I agree that we should also consider whether the applying Arizona law could deter the Arizona officer. I think when we think about that, in this case, the answer is clearly no, for at least two reasons. The first, to answer your question directly, is I don't believe an Arizona officer could obtain a warrant that could be executed in Nevada. If a warrant were issued in Arizona, it would be bound by the territorial limits of Arizona. If you take that warrant over to Nevada, they don't have to follow it. The Nevada officers could ignore it. We cite a treatise in our brief, Lefebvre Search and Seizure, that takes the approach that broadly the United States treats warrants as having only the applicability of their territory. That treatise actually cites another case out of Ohio where they actually suppressed evidence when Ohio issued a warrant and then it was executed in California. I can give you the citation for that if you'd like. But the point is, there's a very real possibility that Nevada would simply ignore this and perhaps couldn't even apply the Arizona warrant because, given all the statutes we cite in our briefing, there's no indication that you could even take an Arizona warrant to Nevada and execute it. The second problem with thinking that we need to deter the Arizona officer is a little more straightforward. Frankly, the Arizona officer did nothing here that could be deterred. There was no culpable conduct. If we think about what actually occurred in this case, the Arizona officer simply asked dispatch to contact the Nevada police and request a blood sample. The Arizona officer did not say get the blood without a warrant. The Arizona officer did not say get the blood at all costs. The Arizona officer simply requested that the Nevada officer get the blood. I think an implicit in that is the assumption that the Nevada officer is going to comply with Nevada law in doing so. So I don't know if we could even say that what Arizona did here was culpable. What could the Arizona officer have done differently, frankly? And the answer is really nothing. And if we decide that there's nothing differently the Arizona officer should have done, there's nothing differently the Nevada officer should have done, then there's no basis for applying either the exclusionary rule or the good faith doctrine of another state.
Mr. Christ, wasn't Officer Reinmuth acting as an agent of Officer Berea? Why shouldn't we take Ms. Cruz's position that the agency law applies here and that would act negatively on your position here, that the blood should not be suppressed?
Well, we don't believe that such an agency relationship exists. For one, if we were to use strict agency principles here, we wouldn't see the Nevada officer as an agent of the Arizona officer because there was no direction or control of the Nevada officer, nor could there be. Arizona, as a separate sovereign state, has no power to bind a Nevada officer to do anything. The Nevada officer can simply ignore any request made by the Arizona officer. The other problem is the cases cited by HAVATONE to this point are not really exactly on point. They're more about the private search doctrine when a private citizen is acting as an agent of law enforcement more generally. We're not arguing that the Nevada officer isn't a police officer or that the Nevada officer wasn't performing a search under the Fourth Amendment. We're simply saying the Nevada officer is bound to comply with Nevada law. And simply requesting that the Nevada officer obtain blood isn't enough to bind them to Arizona law. And there's some real practical difficulties with that, too. If you go back to my hypothetical where the defendant has robbed convenience stores in multiple states, if all the officers from those individual states contact the officer in State E and says, can you get blood for us, it's difficult to imagine that you have to give 5 crash courses on the different laws of the states so that the officer in State E knows, okay, I can do this and this, but I can't do that. And that, again, I don't think is the best application of the good faith doctrine because it wouldn't really lead to meaningful deterrence.
So in this case, you say it wouldn't bind the Nevada officer to Arizona law because there isn't enough. There is the request, and at the end of the request, that's the agency, if there was any agency, it would not rise to the level of an agency relationship, correct?
I think that's one reason why we shouldn't apply Arizona law, yes.
What would be enough?
Would be enough? I think you would have to ask if there was culpable conduct by the Arizona officer. And about the only thing I can think of is maybe if the Arizona officer knew that Nevada had more favorable law and intentionally transported the defendant to Nevada in order to avail himself of that more favorable law. Because then you might think there's something that you could deter the Arizona officer from doing. But that's clearly not this case, because the Arizona officer played no role in the decision to move the defendant to Nevada, nor is there any indication that anyone knew or thought that Nevada's law was more favorable. So there's no kind of objective bad faith in that sense. But not only is there nothing approaching that, but I don't really think anything short of that would really apply.
Thank you.
The other point, once we've decided that Nevada law is the best, or the appropriate jurisdiction under the good faith, I think this matter gets a little more straightforward. I think it's important to keep in mind that there are multiple good faith doctrines by the U.S. Supreme Court, and we're adopting one of them here and not another. So there is cruel, which says you can't suppress when you have good faith reliance on a statute, and that is not the good faith doctrine we're applying. We're not arguing that Nevada officers have relied on any kind of Nevada statutory law in performing the search. The relevant good faith doctrine for this analysis is actually Davis, which is where the officer reasonably relied on binding precedent. And here we have Nevada's decision in Galvin, which years before the search treated the natural dissipation of alcohol as a per se exigent circumstance. And I think part of why that's important is a little bit of a history lesson. When the U.S. Supreme Court decided Schmerber, there was a jurisdictional split on what that case meant. And later on, when the U.S. Supreme Court takes McNeely, they acknowledged the split. And essentially what you had happen was you had some jurisdictions that treated Schmerber as adopting a bright line rule, saying any time that you suspect that there's alcohol in the defendant's blood, you always have exigent circumstances. Then there were other jurisdictions that said, no, it's a case-by-case determination, and the presence of alcohol is just a really good factor in considering whether there was an emergency. The Galvin decision in Nevada clearly took the bright line approach, and in HAVATONE 1, our Supreme Court said that Arizona had adopted the case-by-case approach. So you had this jurisdictional division about what Schmerber meant. So it's not enough, I think, to say, well, Schmerber clearly meant that you didn't have per se exigent circumstances, because that was only true in Arizona. If you were in Nevada and you had read Galvin, you would think the opposite. And frankly, that's just like Davis. Davis itself involved a case where you had a jurisdictional split about when you could search a vehicle incident to arrest. The 11th Circuit allowed the search that occurred in that case, even though the U.S. Supreme Court later decided Gantt and decided those sorts of searches would be unconstitutional. That didn't stop Davis from saying, well, even though Gantt came out, before Gantt, the 11th Circuit took the opposite approach, and we had good faith reliance on the binding precedent of the 11th Circuit. So I think that's sort of similar to what's going on here, which is you have this divisional split. Nevada's taken one approach, Arizona another. Since we're in the universe of Nevada law, Nevada's good faith law at least, I think that's what we're bound to follow.
Justice Bullock in HAVATONE 1 wrote quite a bit about a recurring systemic negligence on the part of Arizona DPS. Is there anything in the record to show that recurring systemic negligence on the part of Nevada Highway Patrol?
No, Your Honor. I think the important word there would be negligence. So that would suppose that there was something recurring and systemic that violated the law. Here, there may have been something recurring and systemic insofar as Nevada probably had a blanket policy of obtaining warrantless searches, but then you have to know whether that's negligent. And if Nevada law expressly authorized this sort of search, I don't think we could call that negligence. And the only reason why the majority opinion in HAVATONE could come to that conclusion in Arizona was based on their interpretation of Arizona law as requiring a case-specific analysis for exigency, even in DUI cases, and that's not the sort of analysis that would have occurred in Nevada courts. If this court has no further questions, we respectfully request that it affirm the judgment below. Thank you.
Thank you.
Thank you, counsel.
And thank you, Your Honors. If I could go back to the court's questions about the deterrent effect on Nevada Officer Reinmuth, I guess the only thing I would add, and I believe it was in our opening brief as well, is that there still would be a deterrent effect out of this case. Again, Officer Reinmuth would have taken no action towards Mr. HAVATONE absent the request from dispatch, Nevada dispatch, which came from Arizona dispatch, which came from the request from Officer Perea. So the deterrent effect would have been he would have had he should have had no interaction with Mr. Havatone in this case. And I don't know if the court has any additional questions about our theory of agency or not. Again, that's part of our theory, is that Nevada would have taken no action against Mr. Havatone as far as getting his blood for law enforcement purposes, absent the request of the Arizona DPS
But doesn't the law
officer.
require more than just a simple request for blood for us to invoke the agency law principles that you rely on in your brief?
Well, Your Honors, I think it was more than just the request. It was a direction to obtain it. It was the Nevada officer's understanding of how quickly he needed to obtain it, and then it was his immediate transport of that and handing it over to an Arizona officer so it could be processed here. So everything he did was with the understanding that it was for an Arizona DUI investigation. So I know the trial court on remand made its own distinction between Officer Perea requesting that the blood draw take place and not giving direction on how it takes place. But again, I think implicit in his request what happened was all the chain of events that Officer Reinmuth undertook. And the state's position that Nevada could have just ignored the warrant from Arizona. I guess the flip side of that is they didn't have to, and there's no reason to believe they would have if it had been attempted as well in this case.
So is it your position that Nevada, since they receive a fair number of cases, airlift cases from Arizona, that they should have a special procedure for patients flying in from the state of Arizona?
A special procedure
For obtaining blood.
To obtain their search warrant or to domesticate or somehow honor, to evaluate the search warrant that was received,
Right.
whether it's deficient or not, that they should have some procedure to deal with Arizona search warrants.
Well, I don't even know if they needed a specific procedure. I think it was just something that was never tried and could have been attempted.
Right,
So,
but if we're saying the defendant was deprived of a constitutional right because a certain procedure was not undertaken, then what is that procedure?
I think the procedure would have been Arizona attempting to get the search warrant, and if that had been given, that Nevada would have given deference to it and acted on it.
Well,
So-
we're assuming they would have, but we don't know that, correct?
Correct, because
Because-
it's never been attempted.
Right, and while there is a legal duty to receive the patient and offer services to save his life,
Right.
and they can't refuse that, they can refuse to honor the warrant.
Correct, but they've never been asked to be put in that position because that process has never been attempted.
Right, but
So-
wouldn't they have to have some state-specific procedure to ensure, if they wanted to accept Arizona's warrant, which really has no force within the boundaries of the state of
Outside of
Nevada?
Arizona, sure. But I think the entire problem in the HAVATONE case specifically is that case-specific analysis was not done at any level. And, when the state talked about the exclusionary rule, and I believe Judge Bean asked about if the record had any information, if Nevada had a blanket policy of not seeking a warrant, and there's nothing in the record in the lower court that Nevada would have had any case-specific exigent circumstances or other reasons to lead you to believe that this is anything other than their blanket policy that Arizona had an issue with Arizona DPS. And Officer Reinmuth had a lot of ability to answer that question in different ways on direct and cross and redirect at the motion to suppress. And what came out was very similar to the officer in Arizona. It was a large gap from the time gap between when he received his original training at DPS in Nevada to when this case happened. I believe it was about 5.5 years from his last training. So he did not have specific knowledge of the statutes. And again, more importantly, he did not have case-specific information regarding this. So I think the same...
The Nevada officer.
Correct.
So now we would expect him not only to have case-specific or more specific information regarding Nevada law, but for Arizona cases, they would have to be familiar with our law and what is required from us.
I think
Right.
that would make it constitutional not only under Sherber at the time, but then the following cases of McNeely and the cases after that. Because again, as Supreme Court referenced, the case-specific requirement was known after Sherber more than 50 years ago. So again, Officer Reinmuth was just doing what he was asked to do without questioning any part of it or trying to obtain any additional information.
He's doing what was lawful under his state law,
Right.
which is what he's sworn to do.
But he was doing it at the request of Arizona for a DUI investigation. That was the only reason he did it.
But if there's a request, as long as you're within the confines of the law that you've sworn to uphold, isn't that what he's required to do?
Well, I think if that were universally true, we wouldn't have McNeely and then cases like it afterwards.
Question. Let's go back to something very elementary. What is the purpose of obtaining a search warrant?
What's the purpose of it? Is to obtain evidence or biological evidence from someone when consent is not available.
Right. And so why does the officer need to go before a magistrate to obtain that authorization?
Because consent was not available and no other exigent circumstances were present in this case. It wasn't pursuant to a medical blood draw. There was no claim that it would even be related to that.
I guess more specifically, what does the magistrate bring to the table in hearing the probable cause statement of the affiant? What function does the magistrate serve in listening to this and issuing the warrant?
Well, finding that there was probable cause to believe the crime of DUI was committed and that the evidence of that would be in the person's blood and that needs to be taken, and there was no consent to take it, and because it's such an intrusive invasion into that person's body, that some neutral party magistrate has to make that determination, that it's required to preserve that evidence.
Right. So it's an independent judicial determination that intrusion into the accused body is warranted based on the information that's provided and sworn to by the officer. But now we're in a situation where that determination really is not binding on those upon whom it is to be served.
Right, but there's no reason to believe they wouldn't have still followed it. Again, the problem in this case was no attempt was made, and I'm out of time, but that no attempt was made, and when you look at Arizona and Nevada DPS, there's not case-specific information as to why this should have been warrantless.
Thank you.
Thank you.
Counsel, we thank you for your arguments. This matter is now under advisement, and we will issue a written decision in due course. Thank you. We're at recess.